Good evening, everybody. I hope everyone is doing well. This is Jonathan. It is about 8:30 p.m. on July 31, the last day of July. I hope everybody had a good July. You're staying cool. Here in Atlanta, where I'm at, was about 90 degrees and very humid today. But we survived, and hopefully August will not be too bad, and then we'll get moving to the fall season. So no guests today. It's just going to be me answering your questions. So let me start with some of the ones I've already gotten here. Christina, who is a regular visitor, says hello from California, that she cannot wait. Well, we're here. Somebody is erasing her messages. It was not me. We have my rated rookies. If I sign with another company to represent me, can I change over to you representing me? All right, this is an interesting question. And basically you can, but you have to get the other attorney or other representative to waive fees. And the form to do this, and let me show you this, is, oops, wrong here, is called a 1696 Sup 2. The 1696 is where we represent, or somebody takes on representation, and your current representative would need to withdraw and waive fees. And you can see here in the Sup 2, the option is I was seeking a fee, but I hereby waive my fee, or I'm seeking a fee and will file a fee petition. Here's the issue. And Social Security makes it really difficult to change attorneys, because if the other attorney, the first representative, does not waive fees, then both representatives, whether it's a lawyer or non-attorney rep, would have to file something called a fee petition. Fee petitions are a nightmare. I have probably 15 of them out there. I cannot get paid on them. They just ignore them. So I will generally not take a case if there's going to have to be a fee petition. So what I would tell you is, whether it's me or anybody else, first talk to the potential new attorney and see if the new attorney would actually take your case, because not every case, is something that everybody's going to want. Assuming that the new attorney wants your case, then you need to approach your old rep and say, will you withdraw and waive fees and fill out this 1696 Sup 2. If they will do that and they will waive fees, then you can move to the other attorney. Basically, that would be filed, the Sup 2 would be filed in your exhibit file, and then your fee agreement, which is the 25%, would be honored. But if the other attorney refuses to waive fees or won't respond to you, then it's going to be really hard to get somebody else, because again, nobody wants to be filing fee petitions, and I just won't do them anymore, because again, Social Security just ignores them. So that is the answer. So you can, but you'll find much more success finding another lawyer if you do not have to have the new lawyer file a fee petition. Rick Torres, hello Rick, how are you? Kelly says, I'm a pet groomer, and as I became less able, I began working for myself, doing a dog a day, so I couldn't do it anymore. I know occasionally dogs accidentally get by. Will that hurt my case? My mom does help me. Probably not. I mean, generally speaking, what you're looking for, what Social Security is asking is, do you have or are you engaged in what is called substantial gainful activity? And substantial gainful activity in a Social Security case for 2024 is $1,550 per month gross earnings. So if you're earning less than that, then you're not going to have a problem with the earnings part. And even if you're earning less than that, assuming that you are not doing anything, basically that's looks like a job. In other words, is it full time? Is it mostly full time? Is it something that would otherwise earn you? Let's say you're doing 6 hours a day. Would that be something that would be something that you could otherwise earn a living from? Assuming that is not the case, then occasionally dog grooming, one dog a day, especially if you're getting help, is probably not going to be an issue. Social Security judges, as well as the adjudicators, recognize that people are struggling, and that if it's going to take 2 years to get to a hearing, you've got to eat. So I don't think that working part-time and earning $500, $600, $800, even $1,000 a month is a problem. So no, I don't think that's going to be a problem for you. And in fact, I think it shows that you want to work, you're trying to work, but you're not able to. So go ahead and groom those dogs. It is not going to be a problem. Annie says, hello from California. Hello, Annie. I hope you are enjoying the weather in California. For all the information, good. I'm hoping you're finding the videos as well as the live stream useful. I'm glad that you are here. Elizabeth says, good evening from Evergreen Park. Where is Evergreen Park? I don't know where Evergreen Park is, but hopefully it's a nice place. G.I. Jose says, for a hearing, who decides the new RFC? And RFC stands for Residual Functional Capacity. And basically, that is going to be the judge. An RFC, a residual functional capacity, is a legal finding. It's a legal determination where a judge decides that your capacity for work is, let's say, starting at light work, which light is defined as standing and walking 6 out of 8 hours, lifting 10 pounds frequently, 20 pounds on occasion. That is called a light RFC. But in addition to that, you cannot climb ladders, ropes, and scaffolds. You cannot bend, kneel, crawl, or stoop. You cannot work around hazardous equipment or moving machinery. These are all reductions to the RFC. And the judge might start with that. And that is an RFC. That is what the judge is determining as a matter of law for your case. And then the next hypothetical, the judge might say, in addition to that, this person needs a 1 or 2 step simple job with no changes in the work site, no changes in the job. That is an additional limitation on the RFC. Then the judge might say this individual needs to be within 5 minutes of a restroom because maybe of irritable bowel or some other frequent urinary urgency and frequency. And that person needs to be within 5 minutes of a restroom. That's an additional limitation on the RFC. Then the judge might say this person would likely be off task meaning not focused on work, for 5% of the workday outside of normal breaks. What does that mean? The vocational witness will say that's not really going to be a problem, and there are jobs that meet that RFC. Then the judge might say, what if the off task was moved to 15%? At that point, the vocational witness would say no jobs. So the judge will identify an RFC that's going to start with sedentary or light or medium, generally sedentary or light, and then the judge will continue to remove or to make that RFC more restrictive to the point where the vocational witness says, I could not place anybody within that restrictive RFC. And if there's no jobs, then you win. The problem is the judge might ask 5 questions, 5 hypotheticals, 3 of which the vocational witness can identify jobs, 2 of which there are no jobs. We just don't know which RFC the judge is going to use to for his or her decision. Now, sometimes you can tell because if the judge asks, let's say, a light RFC with no other limitations, of course there'd be jobs. Then the next question is, our hypothetical person is 15% off task. Well, if that's the only question you've got, the judge is either going to decide there's nothing off task, which doesn't make any sense if you've got a herniated disc or you're on significant pain medications, or it's 15%. So generally, if the judge moves right from a non-restrictive RFC to one that's very restrictive, that's usually a pretty good sign. I will also tell you that the attorney can ask a question, an RFC question, but of course the judge is not bound by that at all. But again, it does help possibly for appeal. So again, the RFC is a legal determination made by the judge, and it's used to determine whether there's any kind of jobs you could do. Now, you'll see forms called RFC forms. In fact, I usually talk about this. Let me show you here. There are a couple of websites where you can get free forms. And like here's one, attorney Mike Merberg has a list of, and I'll put the link to this in the comments here. And basically there's free functional capacity forms. Mike calls them residual functional capacity forms list. Technically, that's not accurate. Technically, this is a functional capacity evaluation. It's not a residual functional capacity, because residual functional capacity is a legal determination made by the judge. But the shortcut a lot of attorneys use is an RFC form, but technically it is an FCE form. But yeah, if you can get a good FCE form that is very restrictive, that is where the doctor has identified specific limitations that would limit you from work, then there's a good chance if the medical record is consistent with that, that is persuasive evidence to a judge. So if you've got a functional capacity evaluation form filled out by your doctor and it is restrictive, it says you're likely to miss 2 or more days of work a month, or you need to take unscheduled breaks every 45 minutes, or you are off task for a third of the day, or you have to have your feet extended. There's any number of things in these functional capacity forms. The more restrictive they are, the better. But if it's consistent with the record and it's the doctor's opinion, treating doctor's opinion, that can go a long way. And I'll tell you, there's some judges will basically take a very, very supportive to you RFC form. That becomes the basis of a hypothetical question, and that can really help you win. Not every judge is going to say, I'm going to accept the RFC form, but many of them do. All right, Rodney. Rodney was actually by my office. They dropped something off. Unfortunately, I was have a grandbaby and I was watching her today, so I was at home working from home, so I didn't get the chance to see you, Rodney, but I did get what you dropped off, and I will get back with you. Jen, my paralegal from Lincoln, Nebraska. Hello, Jen, and I'm glad to see you here. Dee Dee, I've seen you before here. Good evening. Nice to see you as well. Okay, nice, says, I now attend now for the best channel for the best lawyer. Well, I mean, maybe not the best, but let's say one of the best. How about that? I'll go with that. Okay, we've got Trish Wade from Tennessee. Hello, Trish. I hope that things are good in Tennessee. I was up there about 6 weeks ago for the NOSCR conference. NOSCR is the National Organization of Social Security Claimants Representatives, and they had their annual convention in Nashville, and I attended it. In fact, the first live stream I did was from the hotel room. So I was in Tennessee. It's about 4 hours from Atlanta, so it's not a bad drive. And I've been to Nashville several times. It's a really fun place to visit. If you've never been to Nashville, it's really kind of a neat place. There's the Grand Ole Opry there, and there's a lot of music there, all kind of music, and it's really kind of a neat place, and it's fun to go there. I have a good friend from Memphis, been there before as well. The Dude says, good to see you. Good to see you too, Dude. I assume you're a fan of, what's that movie with, I can't remember the name of it, but that's the movie with the dude in it. It's a kind of a cult movie. I don't remember the name of it. Maybe somebody will remind me. Jenny Jo Lee. Hello, Jenny Jo. Okay. Hey, Wolf. Hello from Bethany Beach, Delaware. Okay, Delaware. I have never been to Delaware, but I understand it is a very nice place. Code Masur from Gwinnett County, Georgia. That is just down the road. Gwinnett County is one of the fastest growing counties in the country, and it's gotten a lot of traffic, but there's a lot of nice stuff out there. Been there many times. Dwayne from Texas. Have you heard of the IAR, Interim Assistance Reimbursement Program, that gives financial assistance to people waiting a disability claim? It's not available in Texas. Dwayne, I have not heard of that. I know that many states have programs to help people who are applying for disability. I have not heard of that one, but so I can get myself a little more centered there. And I have not heard of that. So it is, let's see here. Why am my head getting cut off there? Anyway, let me see if I can fix that. Okay, well, I can't, so I don't know why. Okay, let me move it back. Okay, there we go. But I've not heard of that, but I think that, I know California has a disability program. I think New York or New Jersey does. So there are some programs out there to help people. I've recently had a few people that are getting on SSI, Medicaid, the presumptive disability, and that happens when you have a case that's pretty strong, and the state will find you eligible for Medicaid, which is really nice because it gives you access to medical care. I've talked about this before, but one of the things I do not understand about Social Security is there's this 2-year wait after you become eligible for benefits before you become eligible for Medicare. So, think about it. You get approved for disability, and you have to wait 2 years from the date of first payment. Realize that the onset date add 5 months to that, 5 full months. Sometimes it's 5.5 months, really 6 months. And then you have to wait 2 years to get on Medicare. Well, that means no source of earnings for, no source of insurance for medical. So you can't go to the doctor. Then they do a review and say, we hadn't gone to the doctor. Well, of course not. I have no insurance and no money. That's one of the things that I know that the new Commissioner O'Malley has been talked about, is aware of it, that really they ought to make Medicare available immediately to people on disability. If you get on SSI, Medicaid becomes immediately available. So it is definitely something that Social Security ought to do. All right, Rodney, how does Social Security view someone going to college to take courses? Good question. Going to college could be seen as substantial gainful activity. So if you are going to college really full-time or close to full-time, that could hurt your case. That could look like you are doing something that is equivalent to substantial gainful activity. It's roughly equivalent, if you think about it, going to college, it's probably more intellectually demanding than a simple entry-level job. But if you're going and you're spending 6-7 hours a day studying, going to classes, that could look like SGA. And I've had people who are going to college and a judge would determine that as SGA. I don't think that going to 1 or 2 courses where you're not under any time pressure, I don't think that rises to the level of SGA or equivalent to earning $1,550 a month. But you get beyond 2 or 3 classes, starts to look like it. And again, one of the questions on the short form or long form for CDRs, for continuing disability reviews, is, have you enrolled in some sort of an educational program? Obviously, if you have, that means that you are potentially engaged in SGA. So I would be careful. If you're going to go to college, I would say really limit it to 1 or 2 courses and not under any specific time pressure. Jenny Joe says, when DDS requests medical records from doctors, they receive all notes, increases in scripts, doctor-patient correspondence. Yes, but, and DDS is the Disability Determination Services. That is the state agency. Realize when you file disability with Social Security, the state you're in contracts with Social Security to do the medical development. And these offices are called DAS or DDS, Disability Adjudication Services, Disability Determination Services. There's a bunch of different names for them. It should be standardized, but it's not. So DDS is going to be the state agency. Let's call it that. DDS is generally going to ask for medical records going back maybe 6 months to a year prior to your onset date. So if you have a medical problem that has been going on for 3 or 4 years, DDS is not going to ask for going back 5 years, even if you tell them you've had a problem going back 5 years. That's what an attorney would do. You could do it on your own. But if I have a situation where, my client has, let's say, back problems going back 5 or 10 years, I'm going to get those records. I will submit them so that the judge has a full picture, because sometimes those historical records can really tell, give a good sense of the struggle this person has been through in the last, let's say, 12, 18 months. May not say as much. Maybe you didn't have good insurance. Maybe there was nothing that could be done. Maybe, they did an MRI and they found that there's really you're not a surgical candidate, and so you're just on kind of long-term pain management. I think the records can really tell a tale. And I'll tell you the same way, you all probably know that Social Security is only looking at past work going back 5 years. But I think sometimes it can be your benefit to let the judge know that you've got a 30-year work history. I was working on a pre-hearing brief today where my client has been with the same company for 31 years. I put that on my brief. Even though they're only going to look at the last 5, I'm going to say, hey, he's been there for 31 years. Long work histories like that means something to judges. So just because it's not something they're going to get or it's required doesn't mean you can't provide it. But yeah, they're going to get all the notes. It's going to show the increase in medication, correspondence, things like that. But I would also tell you, look at the notes. Your attorney, or you can, if you have a portal, you can get copies of those records, and sometimes things are not in there. And one of the things, for example, with medication scripts, you make a very interesting point here. Let's say that you are being prescribed some sort of a pain medication, let's say tramadol, 4 years ago. then it was increased to Percocet, then it was increased to Neurontin or changed to Neurontin. You could make a pretty compelling argument that the increase in pain medication is reflective of the fact that your pain is increasing. And so that would be evidence, in my opinion, that would be very relevant for a judge. So if you've had changes in pain medication over the years that have steadily been increasing, or the medications had to be changed because they weren't working and they're looking for something that would work, that is a relevant factor. I'd want to know about that. I would put that in my brief. I would ask questions about that in testimony to show that my client was having trouble keeping the pain under control with what was being prescribed. And I think the history of the changes in medication can be very useful. And if you think about it, you don't necessarily want the judge to have to dig in and find all that stuff. That is really something that you can provide the judge. And again, that's what an attorney does is, we'll find stuff in the record that maybe needs to be highlighted. And when I do a pre-hearing brief, I'm going to highlight that stuff. Again, the long work history, the change in medication, the ineffectiveness of medication over time, the addition of, maybe additional medical problems, maybe some sort of a chronic pain syndrome or maybe depression that set in. I've mentioned this before and I'll say it again. When you're appearing before a judge, and to some degree when you're interacting with Social Security, you want to tell a narrative. You want to tell a story. And so that story is one where you want to make sure that the judge understands kind of big picture what's going on with you. And so, by telling that story, it humanizes you before the judge, number one. And number two is it gives the judge a kind of a historical sense of what you're going through. You just didn't appear out of nowhere. You struggled for 5 or 6 years while you worked. You had surgery 6 or 7 years ago. You came back and you fought through it. But now, because of a fall, because of, arthritis buildup, advancing age, things have just gotten worse. You got to tell a story. And I'm a big believer in creating a narrative for a judge through your testimony and really through a pre-hearing brief as well. Okay. Jason says, I have agoraphobia. Will it hurt my case if I go outside? Again, I think that, agoraphobia being a fear of, of open spaces. A judge is going to ask you, how often do you go outside? And then you always want to tell the truth. And obviously, if you've got medication that's helping you deal with that, that's going to hurt your case a little bit. So, I would never tell somebody stay inside because, you want to win your disability case. You want to get healthy and go back to work. I'll also tell you that in my experience, I don't see a lot of approvals on agoraphobia. It may be part of an underlying mental health problem, but I've never had a pure agoraphobia case get approved. So, you probably need something else than that, but that would again be something that would be an add-on to other medical problems. And, if you do go outside, maybe keep a diary as to what happened and the problems you ran into. All right, Jenny was asking about the records that, does SSA to DDS get all the records? I think portals are a really good resource. Jen and I, my paralegal and I, we use portals a lot. Sometimes you have to literally go to the doctor's office and say, I want copies of my records. One of the issues I will tell you is attorneys, when we request medical records, many times the doctor's offices want to charge a lot of money because a lot of medical records they are getting are for personal injury cases. And personal injury lawyers can recoup those fees. So let's say that you've got a bad injury case, and you settle the case for $150,000. The money goes to the attorney. The attorney can take out the $500 or $600 that he or she spent on medical records. Doesn't work that way for Social Security. So it's really hard for an attorney in a disability case to come out of pocket $400 or $500 for medical records because there's no way to get repaid on it. You could file a fee petition, but as we talked about, that's really not that doesn't make any sense. So I use patient portals a lot. There's also something called a HIT, or Health Information Technology, that we can use, and that's being used more and more for Social Security to get the records for us, and soon we'll be able to use that system. There is something called High Tech, which we can use, but a lot of times it's just a matter of telling my client, go to your doctor's office, get copies of your records. In many states, you're entitled to copies of your records, and that's where I would get them from. Okay. Okay, Freddie. I am 57 years old and filed, excuse me, for SSDI in January of 2024. I've had my CE, consultative evaluation exam, for arthritis in my neck and arm and depression. I was approved by DDS after quality review. The case sent back to DDS. This is unfortunate. So what Freddie's telling us is 57, which means the grid rules probably come into play. That's a good thing. It's always easier to win over 55, 57. The CE, the consultative evaluation, apparently came back in his favor. DDS, the state agency, found him disabled, but it went to quality control. And somebody there says, wait a minute, we don't think that this was a correct finding. They're going to send it back to DDS. I think you know what's going to happen. DDS is going to find you not disabled. You're going to have to appeal it. Then you have to go to a hearing. It's unfortunate because DDS, you know, it's rare that they do and approve a case, but when they do, and then quality control comes back and undoes it, it's really, really frustrating. But Freddie, I'm afraid that you're probably going to end up going to a hearing. Would be my guess. Kelly. Kelly from California. Thanks for the advice in treating a client important, making them feel at ease. Words of experience as good as gold. Thank you very much, Kelly. I really appreciate that. You know, again, I think that this is an area where there's not a lot of great information out there. I started doing these videos maybe 10 years ago, I think 9 or 10 years ago, my video channel, just to really explain how it all worked. And it kind of grew organically. And the next thing you know, I got 400 videos, and then I started doing live streaming. And you know, I'm just a big believer in sharing what I know because you know, this is something that, you know, look, for a lot of people, this is a lifeline. This is how you survive, how you eat. And so, you know, the more people that can get approved that are deserving, the better. I mean, I talked to somebody today, I will tell you, and you know, Jen will certainly attest to this. I talk to people, you know, many times who've already filed, and they say, I want to hire you. I'm like, well, why don't you wait and see what happens? See if you get approved. And here's some things you could do to maybe improve your chances of getting approved. Yeah, I want the case. I want to, you know, but we got plenty of cases. There's plenty more. But I think if you treat people the way you want to be treated, and a lot of times that means, you know, try to do it yourself. If you've already filed, let's just wait and see what happened. And then, you know, if you get denied, hope you call me. But, you know, I don't think it's appropriate if there's really not much I can do. You've already filed it. You've already, you know, the medical record's being developed. You know, there's probably, in the case profile is good, you're 57, you've got, you know, herniated discs. You know, there's probably not a ton more I can add to the party. You know, why would you pay me? I'd rather you get 100% of the money. So that's just my take on it. You know, there are some times when people want me to get involved because they don't want to deal with all the paperwork, all the forms. I get that. But if you can do it yourself and get 100% of the money, go for it. Roan says, I filed for Social Security disability in January of this year for schizoaffective bipolar depression. It's 25. You have a chance of winning. I think you have an uphill battle. I think that anybody in their 20s is going to have a real hard time because Social Security is very aware of this looming default, as it were, that they're going to run out of money, the fund that pays disability benefits. So there is a understated or unstated message to Social Security decision makers, judges, adjudicators, is to be very, very careful about approving somebody in their 20s, because if you get on, you could be collecting for 40 years. And, you know, that's a real drain on that trust fund. So I think that's going to be a real problem. I do think that mental health cases are probably an exception in the sense that you can have a significant mental health problem at 25. Again, there is still a perception that somebody in their 20s is probably more likely to be able to get past certain of these things, or that there's not enough time has gone by to grow out of some of these mental health problems. I think to win at 25, you're going to need really, really, really strong support from a long-time treating psychiatrist, somebody who's showing that you've tried multiple medications that have not worked. Maybe you've been hospitalized, inpatient hospitalization, God forbid, suicide attempts. You know, there's going to have to be a really, really strong record. If you're getting, you know, medication, Zoloft from your family doctor, ain't going to work. If you're, you know, seeing a psychologist or a social worker every 6 months, that's probably not going to be enough. So I think you're going to need, you know, I would say, put it this way, you know, and in your 20s, you know, let's say if this is the top of the screen, this is, you know, this is what, you know, this is a winning case. You need to be right about here in your 20s. You know, if you're in your 50s, maybe you need to be here. It's just you need a lot more evidence when you're in your 20s. It's just the way it is. I mean, I wish it wasn't, but that's just the way it is because of the trust fund issue. T Cash says SSDI says it was approved medically 4 months ago, but said it must be approved for non-medical. How long should I wait? Another year. I haven't had income in 2 years. I worked nonstop 45 years. All right. Non-medical typically means they're looking for evidence that you have not been working. In other words, they're going to look to see, are there any earnings that have come in your earnings record since your onset date? So if you've tried to work, they're going to want to see, is this substantial gainful activity? They may want to see, is there any other activity, going to school, volunteering? These are the non-medical factors they've got to go through. Again, it used to be a few weeks. Now it's getting to be several months. I've got a couple of them that are people are waiting month after month. In fact, Jen, we were chatting today, and she called on one of these cases we haven't gotten any money on. I think she was on the hold for 75 minutes, then maybe got hung up on. So it is a real problem. They don't have enough people. So it shouldn't be another year, but I think it's going to be probably, I would assume, give it a couple of months for them to make the non-medical. Although, again, I've got cases where I got approval 3 weeks ago, the money is there now. So it's just, and I will tell you this, sometimes they'll pay me before they pay my client. And so, we sometimes have to follow up on that to make sure that there is, the money's coming through the way it's supposed to come through. Rebecca, do you think RFC is more useful than a written letter explaining and advocating for your disability? I think you mean an RFC form. I happen to like RFC forms or FCE forms because they're a checklist. In other words, they ask a bunch of questions, maybe 18, 20 questions that really go to the heart of work limitations. And that's what Social Security is all about. So it's a checklist for a doctor to fill out. A narrative report or a letter can go into those things, but it's more work for the doctor. A doctor can complete an FCE checklist in 15 minutes, but to write a narrative report might take an hour. So I think it's easier for the doctor. I will tell you that some of my colleagues, I have a good friend of mine, Stuart Barish, who's a very, very capable, very good attorney. He's a much stronger believer in narrative reports. I think functional capacity forms are just as good, if not better. So that's going to be something that everybody's got a different opinion about. My opinion is an FCE form is the way to go because it's easier to get them filled out. Do all reps have access to the records SSA has? Thanks for all the great info. My pleasure. Once the case is filed, we have access to something called the ERE or something, Electronic Records Express. That's what it stands for. And so at the beginning, at the initial recon, we can see sections E and F, which are the medical records they've obtained. That is most of everything. Now, that's not organized. It's not numbered. It's not, they haven't gone through and taken out the duplicates, but it does tell me what they've received. When you get to the hearing stage, the file is what they call worked up, where they go through and they take out the duplications, they number the file. It's A, B, C, D, E, and F, section F being the medical records. We get to see A, B, D, E, and F. We don't get to see section C. I don't know what's in section C, but A is like, just determinations. B would be like the application. D would be non-medical development. E would be, or something else. B would correspondence, and F would be the medical records. I may have that wrong, but something to that effect. So, and then there'll be a part of the file that is not worked up, which may contain older records or things they didn't think were important. I always go through that because every once in a while there's something really important in there. But a lot of the stuff, like some of the forms you fill out, the activities of daily living or the disability reports, they're available to me at the hearing level, but they're not necessarily available at the initial and recon. So eventually, yes, I will get access to everything, but at initial and recon, I'm only going to have access to the medical record. And that is pretty much everything Social Security has. And we can get you, one of the things I do for people is I'll get a printout of what they've got. All right, here is Garrett, I'm sure, is online telling people, as you see down below, if you'd like a case evaluation, that is the link to click on. And if you don't know what Bitly is a link shortener, and so it goes to a longer URL, but this tells us how many people are coming from the live stream. So it's helpful if you are coming from the live stream to use this link, bit.ly/contact Jonathan3, capital C, capital J, and the number 3, and that tells me where it's coming from. So that would be helpful. Michelle, hello from Ohio. Where in Ohio are you? It's interesting. Ohio, I didn't realize, a big state. A lot of big cities in Ohio. A good friend of mine, one of my closest friends, is from Columbus, Ohio. And I've got another friend in Cincinnati, one of my oldest friends from Cincinnati named Robert. So yeah, it's a big state. I don't think I've ever been to. I was in Ohio one time for a conference, and it was like right next to. We were either the hotel might have been in Kentucky, but I think the conference was in Cincinnati, I think, or Cleveland, whatever's next to Kentucky. I think it was Cincinnati, but that's the only time I've ever been there. DDS didn't do a POMS on the new condition I applied for. Surprise, surprise. And what you may be talking about, I don't know for certain, but there is something called the POMS. I'm going to show you what that looks like. And the POMS stands for Program Operation Manual. And this is an example of one I use a lot, Program Operations Manual System. This is basically instructions for Social Security. And this particular one, which is DI 25015-017, talks about how Social Security should evaluate transferability of skills. And why this one's really important to us is that when you get down to here, if you are limited to sedentary work and you are age 55, then there is a standard here that says minimal or very little vocational adjustment. We're looking at transferability of skills. So if you're 60 and you're limited to light work, then transferability of skills would be very limited vocational adjustment. Why that's important is one of the things, if you look at the grid rules, is, and let's take a look at the grid rules here. And I'm a big fan of using the grid rules. Let me go ahead and show you that. If you look, let's say here at the grid rules and the light grid rule, and basically what this means is that if you are limited to light work, standing and walking 6 out of 8 hours, lifting 10 pounds frequently, 20 pounds on occasion, you are still disabled. So even if you can do all these things, and again, lifting 20 pounds occasionally, standing 6 hours, you're still disabled. It changes the definition really in your favor. And if you look at 202.06, you're a high school or college grad, but as long as you show you don't have transferable skills. Well, if you are 60, okay, basically Social Security's got to show that you would have to make a minimal vocational adjustment to a job, which basically means that you've got to be able to go back to exactly what you did before. And you couldn't, that's why you stopped working. You know, it's a really, really powerful combination to use 202.06 and DI, this POMS rule, the 250-15. It's really, really powerful because basically it really ties their hands and they almost have to approve you. And again, if you're 55 and you're limited to sedentary, a little more difficult to do, that standard applies as well. So, you know, the POMS can be a very, very powerful tool in addition to the grid rules if you are limited to sedentary or light and you're 55 or 60 respectively. So that's why I think that's what GI Jose is talking about is that, you know, adjudicators many times at the state agency, they don't know how the POMS rules work. That's that's a little sophisticated getting into, you know, transferability of skills, or they may know, but they may not feel comfortable making that kind of assessment. That's really something that they want to leave up to a judge. So, you know, I've had adjudicators call me out on this saying, you know, we understand the POMS, we understand grid rules, but realize we don't have the authority to make some of these transferability of skills analysis. That may be the quality control issue that somebody mentioned before, that somebody at the state agency said, we're finding that this person doesn't have transferable skills. That's really a vocational determination, something that a judge might make. But you start to see that a state agency, their hands are a little bit more tied. I'm going to try to get an adjudicator, state agency adjudicator on the program here, a live stream one of these weeks, and we can hear more about what the adjudicators are thinking in terms of the POMs and in terms of the grid rules. I will tell you that, again, having spoken to many adjudicators and hearing, hearing from them on comments or sometimes by email, some adjudicators are sharp as tacks. They're really, really smart, and they're really dedicated to do their job, and they want to do the right thing. Others are not so much. And of course, that same standard applies to judges, it applies to lawyers. Not everybody is going to give it 100%. But, a good adjudicator, and I've had adjudicators that came to work for me as, legal assistants and paralegals. One adjudicator I had a number of years ago became a paralegal. She's like, look, we're looking for, in her case, she goes, I'm looking for a way to approve the case, but I know that if I make this leap, if I decide somebody doesn't have transferable skills and there's nothing behind that, it's going to get reversed, and that's going to work against me in my review. So, they have limited authority in some cases, whereas the judge is going to have more. So, G.I. Jose noting that the DDS didn't do a POMS analysis, could be because the adjudicator doesn't understand it, or maybe because they didn't feel comfortable getting to that level of analysis. Petra says, my daughter lost her SSI via ALJ hearing, administrative law judge hearing, even though the judge said she was disabled, not able to work. That's been more than 6 months ago. Where do I go? Do we apply from scratch? Well, if the judge said she was disabled, that doesn't make sense. Why would she be denied? You do have 60 days after your denial to file an appeal. But again, you've got to find somebody to do that. There are some lawyers that specialize in appeals counsel review. Assuming you did not do that, it's been 6 months, you would have to start over again. And again, SSI, is not the same as disability. SSI is supplemental security income. It's based on very low income assets. So again, did she lose because her assets or in-kind support was a problem? Was it because of the medical? I think this would be something you want to look real closely at. I will tell you though that, many attorneys don't take SSI cases because the offsets for in-kind support, family help, things like that, reduce the SSI. And, if your SSI ends up being $50 or $60 a month, there's not enough money for an attorney to get involved in it. So it is harder to get an attorney for SSI. But if it's been 6 months, then I would say you need to start over again. How do I talk to my lawyer about settling my workers' comp case? 3 lawyers have aided me in the process. I feel settlement. I'm going to end this. Okay. Workers' comp it does not play nice with Social Security. And the reason for that is if you're getting workers' comp benefits, like weekly wage benefits, or we call them TT benefits, TTD benefits here in Georgia. If you're getting weekly wage benefits, then that's going to offset your SSDI dollar for dollar. So if you're getting SSDI, or if you're getting workers' comp, every month you're getting workers' comp, you're not going to be eligible to get disability. Again, attorneys like me get paid based on past due benefits. There are no past due benefits if you are, if you're basically getting, can I comment here? If you're getting workers' comp, there's no past due benefits, so you can't get a lawyer to take it on a contingency. So if you settle your case, you want to make sure that the settlement has some language in there that basically says this settlement represents a payment over your expected lifespan, the next 20 or 30 years. Therefore, the offset per month is $15 or $20. That's not going to hurt your Social Security case, and a lawyer like me would take that case. I talked to somebody today about that. She settled her workers' comp case for I think $9,000 or $10,000, but I wanted to see the settlement to see, is there that language, we call it Hartman language, to basically characterize your settlement as your lifetime earnings, so it doesn't interfere with the Social Security part of it. So I would say that if the time is right to settle, then you want to make sure that language is in there. You've had 3 attorneys. that's another issue because you may have liens from the attorneys. So getting it settled can be a problem there. But, trying to get it settled will make it easier to file for Social Security. There's also an element here, and I hate to overcomplicate this, called a Medicare set-aside. And basically what that says is that if you have a workers' compensation, Medicare is going to say, well, some of the money that you're going to be getting in settlement should be used for your future medical care. You're not allowed to kind of foist that on Medicare and Social Security. So many times, if you have a workers' comp settlement, you've got to have a Medicare set aside, and you've got to agree not to file for Social Security for like 39 months because you don't want to put that burden on Social Security or Medicare. It gets complicated, as you can see. So I would say talk to your comp lawyer about this, see what the settlement's going to provide, and whether you've got to wait any time for it, whether there's any sort of offsets, whether you can get that language, lifetime benefit payment language. But it does make it more complicated when there's workers' comp. The dude, the Big Lebowski. That is exactly right, Kelly. The Big Lebowski. I saw that a few years ago. It's one of these movies that's got, I think Jeff Bridges was in it. It's kind of a cult classic. I didn't find it like amazing. Some people have seen it 30 times, like the Rocky Horror Picture Show. I thought it was okay. I didn't find it, insanely funny, but, it was clever, but I didn't find it like ridiculously funny. But, a lot of people liked it, The Big Lebowski. That's right. Vincent, you've been here before. Hello, Vincent. Garrett, good evening. Garrett works with me in building my practice, and I really appreciate that. And the dude, we got another Big Lebowski. They stole your handle to make the movie better. I think it's the other way around, dude, but maybe. I think Jeff Bridges' character is the dude in the Big Lebowski. So if you have not seen it, it's worth checking out. If you can see it, on Netflix or something, it's worth checking out. Petra. Okay, well, if you've reached out to us, I will double check that. Jen, if you would make note to see. We use a program called Clio Grow to track all of the leads. And I'm not going to look at it right now because, again, your information is confidential. But normally we're pretty good about getting back to people, or if it's something, if we're overwhelmed, there's a few other lawyers I'll refer to, but I will make sure that, Jen, that we check on Petra Butler to see has somebody responded to her. And I'm sorry that we did not if we missed it. And you know what, if you wouldn't mind, send me an email just at ssdanswers123, ssdanswers123 and I'll make sure that I follow up with you. Crystal, Atlanta. I am in Atlanta, Crystal. Hello from Atlanta. How long does it take to hear from a mental health exam and the recon? This is the second time doing a mental exam. Well, what Crystal is asking is she's had a consultative evaluation, a mental consultative evaluation. Normally those reports get to your file in about 2 weeks, 10 days to 2 weeks. They don't send it to you, however, but your attorney can get a copy of it, but they don't send it to you. I suppose you could make an appointment with the adjudicator and get a copy of it, but that's something that when I log into the ERE system, sorry about that. I can get a copy of it, so I can get a copy. Your attorney can get a copy once you're represented. But the answer is about 10 days to 2 weeks. How should I talk about how much I can get paid? It's been years, haven't been able to work. I'm still young. I'm young still. Should not pain issues, nerve pain and spasm every day. How should I talk about how much I can get paid? It's been Ace Buggy. I don't really understand what you're asking. I'm sorry. I don't know what you're asking. If you're saying, I don't really understand. So maybe you can rephrase it. I apologize. I just don't really get what you're asking me there. Christina says hello to Garrett. And Garrett is in some place in deep, dark, upstate Michigan. I'm not sure where he's at, but he's like, let's put it this way. Sasquatch and Garrett have never been in the same room or same picture. I'm just saying, I don't know exactly, what that means, but I'm just saying they've never been in the same room at the same time. Okay, PMF. G, if a person on SSDI experiences domestic violence, how does getting a new Social Security number work? Especially if the person is affiliated with a DV shelter, domestic violence shelter, and seeking guidance in the matter. I do not know. You're asking a question that is probably one that you would talk to Social Security directly about. Greg Brinkley, Greg at gregbrinkley.org, might be able to answer that. I think that Social Security does not make it easy to get a new Social Security number for obvious reasons, but I think that there is a procedure to do it, but that is way beyond what I do in a disability practice, so unfortunately I cannot answer that. Okay, Trish Wade says, I looked up a close previous job description of the DOT. Can you explain the line GOE 0712 strength SGEDR? Okay. What she's talking about is if you go to occupationalinfo.org, that is the DOT or Dictionary of Occupational Titles. And these are all codes for different capabilities. I'm not sure about GOE. I honestly don't know. I could look it up. I don't know off the top of my head. Strength is S, which means it's a sedentary job. Strength can be sedentary, light, medium, heavy, or very heavy. GED, general educational requirements. Reasoning, R4 is reasoning. M, I think, is math 3. Language is 4. SVP is 7. The SVP stands for specific vocational preparation. 7 is a skilled job. SVP 1 and 2 are unskilled. SVP 3 and 4 are semi-skilled. SVP 5 and up are skilled. DLU, I'm not sure what that stands for. But basically, if you've got a skilled job, past work has been skilled, then if you go to the grid rules, you've got to show that any transferable skills that you might have obtained because you've had a skilled job that do not transfer. And again, the way I get rid of transferable skills would be pain, medication, side effects. But your past work is a sedentary skilled job. It could be something like an administrative assistant. It could be something in the medical field. But again, a sedentary job means there's not a lot of physical there, but it requires a certain level of education. It requires a certain level of training. By definition, I think that to be skilled, you've got to have a job. You've done it for at least a year. And actually, that's an interesting point because I've had vocational witnesses testify that a person did a skilled job and only did it for 4 months. And if you ask the vocational witness, that is not enough time to pick up the skills. So if you only did the skilled job for less than a year, then you don't have a skilled work background. So I think that's something to look at. But that is, assuming you did that job for 2 or 3 years, that is a skilled job, and to meet the grids, you're going to have to show that you don't have transferable skills. Either A, because you are 55 and limited to sedentary, or you're 60 limited to light, or that the skills that you've acquired do not transfer at age 50 or 51 because of severe pain or medication side effects or depression or something else that would interfere with transferability of skills. And again, that's where that, POMS goes into effect if you are 55 or 60. Nomad, my judge gave no weight to my doctors or their own doctors who all spoke in my favor and ignored my doctor's letter stating he looked at the listings. I made 2 of them without question. My lawyers, ... are even shocked and appealing to the appeals council. Who holds the judges accountable? The appeals council and eventually the district court, would reverse if those things were done that badly. Technically the Commissioner of Social Security, it's an administrative agency. And again, if you follow this, you know that there's some new things coming down the pike because the Chevron doctrine, which is where the courts are giving deference to administrative agency decisions, that is no longer. So what that means for Social Security, we don't know. But the answer is, in theory, Congress could look at the performance of a judge. More likely the commissioner is going to do it. There's nothing I can cite to other than to say, I think a judge who gets reversed over and over and over, the appeals council might look at them. This administration, Social Security administration might look and say, what's going on here? Why is this person being reversed? And realize that when they get reversed, it costs them money because now the case has got to go back for another hearing. You've got to pay another vocational witness, maybe get a medical expert. So you've got more expert witness fees. The judge has, time he's got to spend on this. There's going to be more attorney's fees, more past due benefits. So, I think that, but is there technically there's like a regional chief judge and there's all these levels of bureaucracy. But to answer your question, honestly, it's not like there's unless there's clear evidence of bias or discrimination, there's not like anybody kind of doing quality review of judges. I think if there's enough stuff that's going on that's negative, it might rise to the level where somebody takes a look at it, either at the regional chief judge level or at the commissioner's level, but not enough judges who are rogue, and there are a few rogue judges out there, are called on the carpet, in my opinion. That needs to happen more. They have called some on the carpet who approved too many, high percentage, but not who approved too few. Aaron says, what happens if I'm above SGA consistently during my trial work period? Will my benefits end after the trial work period, or go to the 36 months of eligibility? Okay, so if you're over SGA during your trial work period, you first of all use up your trial work period months. Let's say you go through your 9 months and then you're over SGA. At that point, you'd go into I think it's 39 months, if I'm not mistaken, of extended period of eligibility. Even if you're over SGA, you'd go into that extended period of eligibility. So that being over SGA, that doesn't mean you're not eligible to go into that. In theory, what that means would be, let's say you're over SGA and you're over SGA for let's say 30 months or 15 months. And then your condition takes a turn for the worse. You can then in theory go back and ask for a reinstatement. Ask for a reinstatement. So, okay, we've got somebody here who was nice enough to make a donation. I'm not sure. GR. Let's see if I can find you here, GR, because GR made a very generous donation of $20, which I appreciate very much. Let me see if I can find GR in here. Okay, I don't see GR, but GR has a question, and I will answer that. And GR made a donation of $20. Greatly appreciated. Thank you. I received a decision. I wish I could put it on screen, but I cannot see it here. I received a decision letter with a partial approval, partially favorable. My online application status is currently on step 4, being reviewed at Baltimore, Maryland. Originally, it was at Athens, Georgia. How long bar for the retro pay? Okay. A partially favorable decision, by the way, means that you are not approved as your original onset date, but you were approved as of a different date. And basically what that means is, let's say your original onset date was September of 2021, you were approved as of November of 2023. That would be a partially favorable decision. And then they've got to go through and do the non-medical review, which is going to, again, determine whether you've had any sort of earnings over SGA after your amended onset date, your changed onset date. And then they're going to look to see, is there any evidence of doing any activity that is SGA. You also, by the way, when you get the decision, the actual notice of decision, you can appeal that. This is a question that comes up a lot. I get people with partially favorables. Should I appeal a partially favorable? I think it depends on A, the evidence. Is it strong to maybe go back and try to go for the earlier onset date? And B, is there a lot of money at stake? If it's $3,000 or $4,000, probably not. If it's $30,000, yeah. I have a couple right now that we filed an appeal, but we had to file a paper appeal. Social Security's lost it. I'm gonna have to try to track down where it's at. So I have a client, and they may try to say, well, you never appealed it. Well, I appealed it. this is, part of the mess that they're in. They lose paper. So, but yeah, you can appeal it theoretically. But the answer to your question is normally after an approval based on a partially favorable decision, it's going to be going through that non-medical review. It's going to take anywhere from 30 to 60 days, maybe as long as 90 days before you see your money. That would be my thought, my answer to that. Okay. Thank you again very much for GR made a very nice donation of $20, which I really appreciate. Okay, let's see here. Let me go down to the next. All right. Michelle says, how does the new look back affect CDRs, if at all? It does affect CDRs. A new look back, it was like late June. They look back 5 years. So, if you were approved, and part of the issue was that there was a thought that you might be able to go back and look at the original decision, you could go back to past work if there was some improvement. Let's say the decision said, we expect some medical improvement, and your past work was something that would have allowed for that. Well, now that past work is only looking back 5 years, so it helps you. I think that the change from 15 years to 5 years is going to help you. So any kind of evaluation of your capacity based on ability to go back to past work, I think is going to be reduced. It's less likely to be found to do past work, so it helps you. Mark, one of my clients, says this process destroys family. Unfortunately, Mark, it can. I think that these long delays are extremely frustrating for people. I've had people living in cars. 30,000 people in last 2023 died. It's just really, really, it's awful. And it's just awful. I completely do not disagree with you. Okay. We have another GR. Thank you very much for your GR. You are being very generous. GR has made a donation. I think we're at like $50 or something, which is really, really appreciated. Thank you very much. And, that just really helps keep this going. Again, I do this, you can see from my basement. I don't know how fancy. I work on my house. A lot of times I have an office, but I do a lot of work in the basement where it's quiet. My dog and I hang out down here. But, I have to update the equipment periodically, and it does really mean a lot when people are generous. It's just, thank you very much. I really appreciate it. All right. Lillian from Facebook. Thank you for being live. Well, you know what? I have a great time with this. I think this is a really neat technology that allows me to interact with people. I get a lot of calls, and obviously I can't talk to everybody who calls because people sometimes they have questions, and I like to answer them. I tend to answer them more by email, but this is a forum where you can ask your questions. I know Walter Knott does one of these a couple of days a week, or I'm not sure how often. Walter's on a lot, and he actually has his phone where he has a number you can call, and he'll take the people on the call, which is kind of cool. I think that it makes it harder to talk to a lot of people, but I think there are a lot of us who do this kind of work that we are passionate, that we want to help people. Even if we can't represent them, we want to answer questions. And Walter is a good guy. He does this. There's other people out there, who do these videos. You do a lot of videos. Michael Liner does some videos. He does good ones. I know that Stephanie Joy, who's been on here, she does them. There's a number of people who do them. And I don't see these folks as competition because we're all trying to help folks out. There's a lot of good cases out there. We share. I mean, if I can't handle a case, I'll refer to somebody that I think would be a better fit, or that would have the time. So this is a really pleasant group of people that do this. And again, I encourage you, if you like this, check out some of the other things out there. Don't not subscribe to this. Come back to see me, but check out some of the other folks who are doing it. Okay, Aaron. I think you've already answered that question about it being over SGA. Kelly says, let me make sure I got Aaron's question. Yeah, okay, I think We already talked about the 39-month extended period of eligibility. Kelly, if you got fired from a job that has skill level 7, but you only work for 10 weeks, so that counts as prior work. I do have a doctorate degree from 2007. I think that if you got fired from a job after 10 weeks, that would not be enough time to acquire the skills to make them transferable, because you've only on there for 10 weeks. And the doctorate degree, again, it's higher level of education, but that does not necessarily mean it's transferable. 2007 was a long time ago. And, your doctorate shows you're a bright person, but it doesn't mean that the skills you acquired in getting that doctorate are transferable. And I would argue that just like, going back to past work for the past 15 years and now 5 years, I think that a advanced degree, when you go back 15 years, 17 years, I think is much less relevant. So I think that you could use that to make yourself more qualified for the grid rules. Stony Tony, been waiting to ask me a long time. Currently waiting. Does renting and living arrangements affect SSI or SSDI? Rent a room, not head of house. If you're renting a room, no, it doesn't affect it at all. Now, if you're SSI, if you're only SSI, or you're applying for SSI for those 5 months that you're not going to get SSDI, and you're getting help, financial help from somebody, a parent, a sibling, a friend, that could offset your SSI. Help from friends or family is not going to offset your SSDI, only your SSI. But renting a room is not going to be a problem, for SSDI or SSI. It's just not. So that I would not worry about that. All right, Nomad is the one who had the judge that ignored all the medical evidence. The judge is consistently below the average approval. I don't say judges can ignore the doctors. Yeah, look, there are judges. If you look at some of the websites out there that talk about approval rates, there are judges at 10%, 5%, 12%. There's a judge here in Atlanta who's at 30% who denies people unreasonably, in my opinion. It's just, this is a problem. I happen to think that if a judge is beyond a couple of standard deviations, from the average, that would make the judge suspect. I've never used that argument, but I might one of these days. That if the judge is so consistently below what the average is, that would almost inherently mean that there's a bias there. Not sure why someone would become a judge if their goal is to just deny people. Again, I will tell you from doing this for 35 years, most people who apply for disability don't want to be on disability. They'd much rather be working. This is a last resort. Many people don't like the idea of taking help from the government. People don't want to be sitting at home looking at the four walls. They get, as you all know, you get pressure from your family. Why aren't you contributing? You get snarky comments from neighbors. Why aren't you working? You feel useless. It's not a good thing. I mean, it's necessary if you can't work, but this is not a free lunch. The amount of money you get is not that much. So, I think for a judge to assume that people are just doing this because they want to make money is absurd. I mean, who's going to wait 2 years to get, $1,700 a month? It just doesn't make any sense. Yet there are judges out there who seem to believe this. And I think there are also judges out there, not a lot, but some, who don't understand that if you don't have a lot of money, you're not going to be able to pay for medical treatment. You're not going to be able to get the best doctors. You're not going to be able to go to rehab or hardening after surgery. It's a different world. If you have gold-plated insurance and it covers everything and you get the best doctors, you're going to have better results. Some judges don't seem to get that. So, the point is that as I mentioned before, there's not like there's anybody, looking at the judges saying, this judge is below average and therefore, we need to investigate. There should be, but there's not. And by the same token, to be fair, there's really not looking at judges who approve at 85 or 90%. That is probably too high. If it's, I happen to think that, a 60 to 65% hearing approval number is probably where it ought to be. It's right now about 48%. There are way more people that get denied that should be approved than get approved who should be denied. So I happen to think that 60% should be the target. but right now it's 48% or something like that. But, they didn't put me in charge, and there's no statistical, goal to my knowledge, or if there is, it's not being publicized as to what they want to do. Again, money talks, and, Social Security's got this looming crisis where they're going to have to deal with it. Congress is going to have to deal with it in 9 or 10 years because they're going to kick it down the road 9 or 10 years, and they're either going to have to increase taxes or cut benefits. And they ain't going to cut benefits, and to get reelected, you start raising taxes. And again, there's this narrative about everybody faking it. It's a political problem. It's a political problem. Okay. Why would a judge go back a year on your award? Well, I mean, if you allege an onset date, back a year, the judge can go back and find you disabled as of your onset date. You only get paid 1 year prior to application. But, if you, let's say we're in 2024 right now, let's say that the judge found you disabled, you alleged an onset date of 2019, the judge found you disabled in 2022. Maybe because the evidence was not strong at that point, what you need to make sure is that the onset date is before your date last insured for SSDI. But a judge can go back a year. I think if you mean go back, meaning give you more time, it's because the evidence shows that. The judge can also move it forward. You alleged an onset date of March of 22. Judge can say, I'm finding you disabled, but November of 23. They can do that too. So it's up to the judge to decide on something like that. So I'm not sure, Bluegrass, if I'm answering your question. If you want to make it more specific, please do so. Even though Glenn says, I got approved for SSI on July 5th, I watched your chats. But, hey, thank you, Glenn. Thank you very much. You mentioned reviews. I'm going to go ahead and put a link up of how to leave me a review. That would be really appreciated. Reviews, as you know, for lawyers is kind of a really important thing. And we really appreciate the reviews because it helps me get the word out. And people check them. And look, I will tell you that, there are some people out there who, have left me bad reviews because I didn't take the case or they lost. And, that's going to happen. But, I think if you give it a fair shot and treat people with respect, my reviews have been overwhelmingly pretty good. So if you find this useful and you would be willing to do it, please leave me a review. Thank you. Thank you, Glenn. I appreciate that. Okay, good question, Scorp. Do you know if CDRs are being conducted on time according to the schedule set by the judge or being delayed because of personnel shortage? What Scorp is getting at is you will see in some decisions that the judge says, I recommend that this case, or I direct that this case be reviewed in 12 months or 24 months because medical improvement is expected. But if Social Security is behind, they may not get to that. So the judge can say it, but it's not required because Social Security does not, they're not going to do it if they don't have the personnel. And right now, as you probably know, Commissioner O'Malley put a hold on all CDRs through the end of the fiscal year, which I believe is September 30th of 2024. So it will probably be longer than the 1 year or the 2 years, or whatever. So no, it is not always done based on the schedule of the judge. And that's just because they don't have enough people. And quite frankly, it's more important, and I think O'Malley realizes this, take this backlog. I mean, if somebody's waiting for 12, 15 months to get an initial decision, that's ridiculous. That person needs to be a priority if we're trying to cut somebody off who's probably still disabled. My opinion. Okay. The adjudicator, Ray says, change the onset date from 3 of 2020 to the date you filed, December 26 of 2020, diagnosed with MS. Boss allowed me to work 12 hours a week but paid for 40 is worth fighting. Well, if you were getting 40 hours of payment through December of 23, it's going to be hard to, that's a hard argument because you're getting paid over SGA. So you would have to appeal it and say, I was getting paid but only working 12. And then what would 12 hours be worth? So yes, you could appeal it, but I would say if you're getting full pay through December of 23, probably not going to be a real strong argument for you because the assumption of you're getting paid for 40 hours, you're doing 40 hours of work. Can you prove you're not? Yeah, maybe. But again, the assumption is 40 hours of pay or over 1550 is SGA. Really hard to rebut that presumption. So I would say, with 85, 90% certainty, it's a real hard argument if you were getting paid SGA or over through December of 23. All right, Jen, my paralegal. Jen, why are you asking about medical marijuana? Right? Something you need to tell me here. Jen is my paralegal in Lincoln, Nebraska. Can medical marijuana hurt your case? Probably not. As you know, some states have legalized marijuana or decriminalized it. Some doctors will order medical marijuana as a pain reliever, as an anxiety reliever. Yet medical marijuana or marijuana is still a Schedule I drug. In my experience, medical marijuana has not been used by judges to find someone is substance abuse. Using substance to the point where it's a material contributing factor. If it's prescribed by a doctor, that has not been a problem. If you're using it for street marijuana, could be a problem. So I think that's I've got a case coming up in a week from this Friday, where my client has significant mental health problems. He uses marijuana 3 or 4 times a week. It's not prescribed. He's in Georgia. We don't have medical marijuana, or we've got it, but it's in a very limited way. Not prescribed. I'm going to have to get past this argument that, if he was not taking marijuana, if he's not using it, would he be better? Hard to untangle that. But I think if it's state approved medical marijuana, you got a card, you're probably okay. And Jen, we need to talk about this because I don't, know why you're asking about medical marijuana, but you'll have to explain that to me tomorrow. Thank you. Jerry says, disability called me and asked him a question about my last job. And a month ago, I think they're in step 4 and 5. I'm a recon, haven't heard anything back yet. Steps 4 and 5 are done by now. All these things with the steps 4 and 5 and the percentage done, that's all a bunch of crap. They're just giving you numbers to make you not be angry at them. There's no way to know where they're at with it. Hopefully, I would say on average, the initial and recon, and Jerry's 54, by the way, which helps. On recon, initial and recon, 9, 10 months, you get beyond that, you should be contacting your elected representative and asking for a congressional inquiry. And basically, just, it's way too long. So I don't care what they're telling you on the, either step 4 and 5, or it's 70% done, a bunch of BS. They don't know, we don't know what percentage it is. And again, the key metric, in my opinion, is how long have you been waiting? If you've been waiting more than 7, 8 months, call your congressperson and get them to do something. All right, Jerry, as I told you, it was 54. Angie, when you say a brief, what does that look like following their attorney? A pre-hearing brief is just a summary of the evidence where I just kind of summarize my argument. In a disability claim, there are 3 ways to win. You can argue you meet a listing, you can argue you meet a grid rule, you can argue that your functional capacity for work has been so reduced you would not be reliable. So I'm going to identify how old the person was at onset, give all the dates, things like that. And then I'm going to make my argument, say, and what evidence supports it. Like I'm working on one right now where my client has gone to a number of different therapists. There are 3 consultative medical or psychological evaluations in this file, all of which say my client has significant problems. So I'm going to argue in my brief that the person has gone to the doctor, they've been in continuous treatment. The ongoing, psychologist treatment does not really talk about work issues, but the consultatives do. And the consultative, one of them says that this person would have a really hard time maintaining attention and concentration. The other says the person would have a hard time with attendance. So I'm basically going to say that the consultatives give us some really good feedback as far as the person's work capacity, and we think this is a fair representation of his capacity, his residual functional capacity. I would ask the judge to adopt it. So that's what I mean by a brief. And again, you can make it informal, but basically just, that's where you talk about the onset date. You describe past work. I may talk about the DOT code. You're going to occupationalinfo.org. I'll just kind of summarize my argument. It's kind of in lieu of an opening statement, quite frankly. This is why I feel my client's disabled. So you can do it in a letter, but I think the more facts you can reference, and if you can talk about specific evidence, that would be helpful. You could point the adjudicator to this MRI report. If it's not numbered, I had an MRI in, April 2023 that said X, Y, and Z. I had a, CT scan in November of 23 that said this. So that's what I would do. All right, Garrett is putting that in there. Let me go back because you'll get mad at me if I don't leave it up there for a second. Contact Jonathan 3 if you want to get a case evaluation. I'm going to put that down below here in a second anyway. Jenny Joe says, thank you. You're welcome, Jenny Joe. Does DDS really analyze, says Justin, the grid rules that really don't happen at the judge level? I would say that they do. And again, Greg Brinkley used to work for Social Security, and he is adamant that adjudicators, claims managers are very aware of the grid rules. I'll take him at his word. I will also tell you, I've talked to adjudicators over the years, and I mentioned the grid rules, and there's silence. They don't know what I'm talking about. So I would say that they're trained in it. They should know. Not all of them know about it. Every judge knows about it. But I think that, if you're going to argue grid rules to an adjudicator, you don't just say, we meet the grid rule. You want to say, we meet grid rule 202.06 because, and you want to talk about the transferability of skills issue, talk about, the education level. You got to explain why. You don't just want to say you meet the grid rules. You want to identify the grid. We think this person meets grid 201.06 and the alternative 202.06. So yeah, I think, the adjudicators do know about the grid rules, but you still want to tell them anyway. Okay, I have Siranjami, can't pronounce it. I know what it is because I've had a case with it. Syrinxes, basically, which are little tumors, and doctors gave me a walker, and a judge gave me an unfavorable just before I got my script. And a disabled veteran, the appellate office granted more time. I think that if you're going to appeal to the appeals council and you've got evidence that, relates back to the time of your hearing, that may be useful in an appeals council review. So I think your appeals council lawyer, yes, should reference that. And certainly if it gets remanded back, you could bring up this new evidence at a remanded hearing. And, the walker obviously makes a big difference. And if you could get evidence that the walker could have been prescribed a year and a half ago, that would make it even stronger. But, you can get creative with these arguments. So I'm sorry you got denied, but you might have a chance at the appeals council. Thomas, how can I determine which condition I was approved? Look at the decision. It should tell you. It should certainly at a hearing decision, it will tell you. At the administrative level, usually it will tell you why. But if not, obviously look at your medical conditions and which ones are the most severe. I mean, at the end of the day, an approval is an approval, but it does help to know what it is. But I know at a hearing approval, it will say, not sure about that. Maybe administrative, maybe you're right. Maybe it doesn't. I don't know. But again, just, look at your record and kind of make your own determination about that. Okay, I think Rebecca Renee asked about RFCs versus narratives. I think I answered that. I think FCE forms are preferable in my opinion, at least. Nature trails. I have spinal stenosis and herniated disc, live in chronic pain. How do I ask my doctor for increase in pain dosage without sounding like a drug addict? It's a tough question because, again, I think you always approach the doctor and to say, look, I want the least amount of pain medication that I can take, but what I'm getting right now, not doing the trick. And is there something else we could try? Is there epidurals would be a radiofrequency ablation, facet injections. And if we're going to long-term pain management, I'll sign a contract that basically says I will not abuse this. But, pain, chronic pain is a major problem in this country. And there's also obviously, when you drink carbonated drinks, that's what happens. But yeah, pain can be a problem because doctors are really concerned about, abuse of pain medications. So I think you've got to, really talk to your doctor about, all the options that might be available to deal with chronic pain. And, if you're going to go to pain management, just, don't ever, buy pain medications off the street. Don't use it up early. You just have to really present yourself as a, legitimate person who is looking for everything else but medications, but this is what allows you to function. And maybe even talk about how the pain medication allows you to function. But yeah, that is a problem because many doctors are reluctant to do it, to prescribe it. Nomad is the one who had a low approval judge. Yeah, I mean, he's saying basically that the judge ignored all these medical records, and it's been 4 years, and it's humiliating, which I'm sure it is. And now, he's lost a lot of stuff, and it's created some mental. Yeah, absolutely. I think it's not uncommon for people to, undergo to have mental health issues, stress, and anxiety because of being put through this ridiculous process. I'm sorry you're going through that, Nomad, but it's not uncommon. Wow, bro. I was approved for SSDI. I've been denied SSI. I haven't worked since 2020. Don't know I was an SSI in the meantime until I received SSDI. Approved medically. Own one house and one car. Okay, well, part of it would be if your onset date was before your application date. SSI is only payable as of the date you applied. If your onset date was more than 5 months before your date of application and you got approved as of your onset date, then the SSDI benefits get paid retroactively up to a year past. But if there's SSI gets paid only as a date application, therefore you would not be eligible for SSI because of the SSDI offsets it. And again, you only have one house and one car. Do you have any money in the bank, or is there any other reason for it? But generally, it's because the onset date was more than 5 months before the date of application, and SSDI offsets SSI. Okay, Mark. Jen is awesome. I know that Jen would agree with you, and she is. Jen is very fortunate to have a Jen working with me because she really does care about our clients, and she makes a real effort to help our clients survive this. And I think that, some of what we do is kind of counseling. And, it's hard. I have a really good staff. I mean, Jen has been with me for several years now. I have another person who's I guess called paralegal, although she's actually, believe it or not, a medical doctor. Her name is Iris. Because it's pronounced it's IRIS, but it's pronounced Iris. And Iris is a medical doctor in Guatemala. And she is a big help to me by reviewing medical records and helping to summarize the record, also to work on cases. So I've got, a medical doctor and somebody who's really good at processing cases. We got Jen. We have Madeline. Some of you, if you're my clients, have dealt with Madeline in Oklahoma City, I think, Oklahoma someplace. And Madeline is, works on new cases and is starting to work on some of the other stuff as well. She's very sharp. Paola is in Mexico. We're international. And she handles some of the phone, handles the phones, and she also does medical updates. I've got Josh in my office handling the mail and doing some of the correspondence. I've got Stephanie in Florida who helps draft up decisions. Got a really good staff, and because of everything's all online, we are all remote, and so it doesn't matter where anybody lives. That's why I can do cases all over, because I'm doing hearings. I do cases out of California and Nevada and Arizona because all done virtually. So it doesn't matter where you are. And again, my staff is evidence of that. People in, overseas, or not overseas, but in different hemisphere, people in Nebraska and Florida and Oklahoma. So it's just really been a big change for me. And, I'm fortunate to have good people. And, back in the day, had to have people locally, and just really narrows the applicant pool. So I'm very fortunate to have Jen, and as well as the other folks that work with me. Jenny Joe, the information I was looking for is not in the portal. I'll try asking her directly. Yeah, that's exactly right. She was asking about where to get medical records. You got to be an advocate in this stuff, and you have to ask for that information. Absolutely. Mark, lately they sent me a letter saying they might stop seeing my monthly payment because I went over the SGA limit. The reason that happens is because I get regular bonuses. Again, you've got to look at the trial work period. If you've used those up and you're going over SGA, you could be, that could be a problem. And, it's one of these things where if you're working part-time and you get bonuses, that could take you over SGA, and that may put you in the extended period of disability or eligibility. So you may have to adjust your work hours so that you don't have those bonuses, because what you don't want to be is in a situation where you're earning just over SGA to take you out of the disability world, but not enough to survive on. And so that sounds like what might be going on here. So it's a real issue. All right, Garrett says, if you haven't asked a question, tonight's the night to get yours answered. Don't be shy. Garrett is trying to make more work for me, it looks like. And you can also email me if you want to, ssdanswers123@gmail. And if I don't get back to you by email, we can use it for the next week. But this is a good chance to get questions answered. Bonuses are out of my control. It's a problem. It's a real problem. If you get enough bonuses where it takes you beyond your trial work period, which remember is a rolling 5-year period of time, and it takes you over SGA, you could be found not disabled by virtue of earnings. And like I said, if you're just barely over it, and SGA is like $18,000 a year, so if the bonuses put you at 19 or 20, you're not really making a whole lot of money, and you're really probably still disabled. But they tend to, because Social Security is a big bureaucracy, they tend to just look at the numbers, and this is an issue. Ace Buggy, I have similar back issues, lower disc issue, got off all pain meds within a year, use cannabis, use me off the pills. Over time, opiates makes the pain worse. There are studies on it. Again, medical marijuana is going to be much more easy to work with than street marijuana. So, I believe you that cannabis can be a nice alternative to opioids. And you're right, opioids have, besides addictive problems, there's constipation, there's rebound effect. But if you're going and buying pot from the local, high school head, that's not going to play very well in the Social Security world, unfortunately. Crystal, I believe, from Atlanta. How long does the middle take? Again, I think to get back, it's going to be 10 days to 2 weeks. Ace Buggy is, I think, the one who's using cannabis. L4, L5 with an S1 affected nerve issues, told me to sleep in bed. You sleep in a hard floor to get a subpar night of sleep. Again, they may ask you to be given Neurontin, which is a nerve pain medication. But like I said, if you go and buy street marijuana, besides the fact that it's potentially dangerous because it could be laced with fentanyl or something, I think that's going to be a problem. Okay, Nomad, third lawyer, second lawyer became a judge. Okay. All right, so Michelle is in Perrysburg, suburb of Toledo. Okay, so I've talked to people. I've got, like I said, a buddy of mine in, Columbus. I know somebody in Cincinnati. I have a relative in Dayton. I know somebody in Cleveland. Don't know anybody in Toledo. So it's, again, a big state, a lot of big cities. But don't know anything about Toledo, but hopefully it's a nice place to live. Wizard. What if you have more medical issues now than when you first won your case? Will it help in your CDR? Yes, it will. I think that if you've got new things, that would be part of the calculation when they do a CDR. So absolutely, you want to make sure they're aware of it, so they would develop that as well. Kay, okay, works for DDS. Okay, great. Kay works for DDS. Love your channel. Use your channel to learn about SSD to get hired at DDS. ACE interview. Okay, if you ever want to be on video, I'm not sure you're allowed to do that, or even do it, just maybe answer some questions. I would love to hear your perspective on it, because, again, a lot of the stuff I talk about DDS, I'm based on what, a prior employee told me, what I've heard from people like, why am I drawing a blank on Greg Brinkley's name, from Greg, other people, but anybody who's there, who's willing to talk to me, that would be ideal. So email me, Kay, ssdanswers123@gmail, and maybe we can get you on, because I think everybody would like to hear what a DDS examiner, who's doing it day to day, what you do, what you know about the grid rules, how you approach cases, how the process works from inside. I was actually looking at Charles Hall, who's a blogger. He publishes the NADE, the National Association of Disability Examiners. They have I think it's a quarterly newsletter. And so he publishes it in his blog. And so I was looking at that, and it was kind of interesting just to hear some of the things that DDS examiners are talking about. I was thinking about reaching out to somebody there. But again, if you want to be on, I'd love to have you. But thank you for the kind words. Rebecca, okay, she's applied for complex PTSD, anxiety, depression. I have support from my psychologist and a psychiatrist. SSDI has not requested a mental evaluation. Is this a good or bad sign? I don't think it's a good or bad sign. I mean, it could simply mean that they feel they've got enough from your treating doctors. That's probably a good sign overall, but sometimes they don't ask for them because they're really busy. I would say, if I had to guess, I would say it's a good sign. And again, this is where, somebody like Kay, who works for DDS, can maybe tell us what her thought would be. But I don't think it's definitive one way or the other. I don't know that you can draw any strong conclusions from that. Will an ileostomy for ulcerative colitis at 62 qualify you for disability? Yes, I think it probably would. I think that is something that if it's not listing level, any case I've ever taken to hearing or argued at the adjudication level, or a person has an ostomy bag, which is where they have to cut a hole in your abdomen, because you can't process foods and eliminate in the normal way. That is usually a sign of a pretty significant ulcerative colitis, assuming that there are other conditions, pain, cramping, the need to change it periodically. You can think about a lot of work issues that arise from having it, the possibility of it, of leakage. There's any number of arguments you can make, but I've never had a case denied, especially at 62. I think it's a winning case. All right. L. Brown, what is that behind me? That is not a little person. That is if you're talking about that is a video light. That is called a pancake light. You're talking about this over here. You're talking about this over here. What is that? That's the pancake light here. That over there is it's a headset, earphones, like for, wireless earphones with a can of tennis balls behind it. And it does look like a Halloween mask. I normally close that door. I forgot to close it. But that is not a Halloween mask. That is a headset with behind it a can of tennis balls. So, hope that answers your question. Halloween costume. No Halloween costume. I used to get dressed up. I used to have like a whole Mr. Spock outfit. That was my Halloween costume, but that was before those. Mr. Spock didn't have any gray, but that was my Halloween costume back in the day. And then once I got older, you can't really do it. Although my kids, when they were younger, would go dressed up as different things. And sometimes I'd put I had like this, it was like a, what do they call it? Like a dreadlocks. I had like a dreadlock wig, and I would wear that answering the door. And I have this like candy thing. It's like a plastic, like a hand, a skeleton hand that says Happy Halloween. And so when the kids from the neighborhood come around, I'll press the button, Happy Halloween, and I'll sometimes wear the dreadlocks. And people look at me like, who is this nutty person, and why is he trying to look like he's wearing a costume? But I did. Okay. How does one survive financially to waiting to see if you're approved? D says, I wish I had a better answer for you other than I do not know. It is a real struggle, and as somebody mentioned, it is cruel at times. It is, Social Security makes it really, really difficult. There is no good answer to that. Marie has spondylosis. Now, spondylosis, Marie, is degenerative disc disease, and it sounds serious, and of course it is serious, but a lot of people have degenerative disc disease. I'm sure I've got it. So you're not going to win on spondylosis. You don't win on a diagnosis anyway. You're going to win if the evidence shows a severe level to the point where it's causing nerve pain, it's causing radiating radiculopathy, radiating pain into your legs, things like that. That is what you need. But just having spondylosis is not probably going to be enough. Danny says, hopefully it comes with back pain. Hopefully it does. Hopefully it does. Jack, hello. It's Jonathan at Mr. Ginsberg, please. Is the Veterans Administrative Hospital doctors any good source of evidence to obtain? It's okay. I mean, the problem with VA records, if you ever looked at them, are that they are voluminous. I mean, it will be, 1,500 pages, and a lot of it's just copies of copies. So, it's not ideal, but it is, it's evidence, and it does show, some problems. So yeah, if that's what you've got, that's what you've got. But I think, if you could get private doctors, especially for, mental health or orthopedic, where you get some sort of another doctor's, non-VA doctor talking about work limitations, that would be better. But I think that I do a lot of cases with VA records and we still win them. So you can certainly use VA records if that's what you've got. And obviously it can be more affordable. Okay, right. So Elle's talking about the workers' comp. And again, workers' comp usually offsets it. Far out, says Garrett. That dates you, Garrett. Far out was like a term used in the 60s and 70s. So Garrett, you must be old like me. I don't know. Marie Berkeley, go to year 3. And again, that's evidence. That's good evidence of severe back problem. Severe back problem. So 3 times a year, yeah, that is a significant back problem. And again, if the evidence shows, radiculopathy, nerve pain, and you go to the hospital because you've got to have a procedure, an injection, that's evidence, good evidence. Pardon, I played 2 hours of tennis today in 93-degree weather. It's humid, so that's why I'm yawning a little bit. And I did win, by the way. So, I'm from here, so I'm from the South, so hot weather doesn't really bother me, but it does tire you out a little bit. But I did take a shower before I jumped on this. I always tell them I got a hard stop at 8, got to be online at 8:30. Okay, DD is almost 59, spoke to the adjudicator on Friday, said they sent requests for latest doctor visits, ready to make a decision, as long as they're received. Any idea how long? I would say give it, a month. I mean, normally they calendar it for 2 months, but, if you can ask your doctor to get it to them sooner, when they get it, they send it to one of their doctors. I would say 2 to 3 months is a good guess. 2 to 3 months. Jack says, Washington State closed. Okay. Washington State closes workers' comp claim without any benefits. That's helpful for SSDI. Says everything is degenerative and pre-existing. Does it help? No, because degenerative and pre-existing doesn't hurt your Social Security at all. That's a problem in workers' comp because it looks like a pre-existing condition. Social Security, they're looking at you as to what's the work implications of your problem. So pre-existing or degenerative is fine. That's good. That's helpful. It's not a bad thing at all. Garrett says, I see a lot of questions about CRPS in the comments. CRPS is chronic regional pain syndrome. It used to be called RSD or reflex sympathetic dystrophy. And basically what it means is you have a pain condition that is pain out of proportion to the underlying medical problem. So let's say, an example I would give would be, let's say you jam your wrists in a car accident. And, you don't break anything, you just jam it. But then you develop this just incredible wrist pain that is way out of proportion to the actual damage to your tendons. That's CPRS, CRPS rather. You have, back pain, let's say you have a mild bulging disc, but you have terrible radiating pain into your legs. It's just it's a nerve pain that is out of proportion to the objective evidence. The problem for Social Security is they're saying, well, the MRI just shows, degenerative disc disease and mild bulging disc. So you're going to have to go to a pain management person to basically diagnose the CRPS and basically say this is real and this is debilitating. So it is a pain condition but it is beyond what the objective medical evidence will show, which by definition makes it difficult for Social Security. Garrett is saying, see no either. So maybe we're asking about medical marijuana. I think I'm not going to ask Garrett about that. I don't really want to know. But okay. Donna missed me last week, but you're back. Donna, I'm glad to have you back. And, of course, nobody's going to come every week, but I hope you can come, I hope all of y'all can come, once every, if not every week, every couple of weeks. I mean, I try to do these, or of course the replays, it's a couple hours. Nobody's going to want to sit through a couple hours, but, I think this is a good way to get your questions answered. The other thing I tell my clients, new clients, to check out the live stream, because you kind of get a sense of the level of impairment that you need to win. I think that there's a lot of misinformation out there, and people ask these questions. You hear me saying, you're 25 with mental health. This is the level of impairment you got to have. You're 59 with, bad discs, you're going to get approved. So it kind of gives you a sense of what you kind of need. And that's kind of why I do this. And when I have, let's say Stephanie or other attorneys that come on, we're just kind of giving you a overall take. Again, 35 years, I can tell you pretty much what I would find is going to be compelling. But I think these are helpful because you kind of get a sense of what is going to work, what would be appropriate. And like I said, I'll tell you if it's not a strong case, I'll tell you that too, I think. GR, who's been nice enough to make some donations here, partial approval, and again, being reviewed by Baltimore. Baltimore is the payment center, and I think I mentioned before that your the delay may be 2 to 4 or 6 weeks, hopefully closer to 2. GI Jose, our medical appointments continuation treatment still relevant after the DLI? Yeah, I think that anything that shows ongoing treatment is part of the puzzle. Again, we're telling a story, we're telling a narrative, and even though you have, your date last insured, and they're going to be focusing mostly on what went on before then, after the date last insured shows your ongoing treatment. You didn't stop. It's part of the story. It's part of the narrative. I think it is very relevant. Kathy Crowley, I had an ALJ hearing on August. I have one on August 2nd. Representative was very pleased with how it went. I don't understand if you had it on August 2nd of 23, but otherwise it would be in a couple of days. So that doesn't make any sense unless you are from the future. And if you're from the future, Kathy, would you please send me the stock market paper or the stock table from maybe a week or two from now? That would be most appreciated if you are from the future. I kind of doubt it, but you never know. But if you had a hearing on August 2nd of 2024, I would really like to talk to you. But assuming it's August 2nd of 2000, but of course, if you had an August 2nd of 2023, you would have gotten your decision already. Maybe you mean July. So the grid rules, it went well. You're 61. That sounds like you probably won. But again, if you are from the future, please send me the newspaper from a week or two from now. Really appreciate that. Okay. Hey, my advice paid off, says support policies, not politician. Good. My advice did pay off. So, hey, you know what? A blind squirrel finds a nut every once in a while. So good. I'm joking. Hopefully my advice will pay off. Representative was able to help me. Unfortunately, now they're investigating some fraud because somebody changed my info online. I hope they catch whoever did it. I agree. But yeah, your representative, elected representative, let them do something useful because, quite honestly, not doing all that useful otherwise. MSAL was awarded SSDI in August of 23, met 2 listings, received overpayment letter. Filed the appeal, give the attorney no feedback. Yeah, you just got to let them go through their process and find out why you got overpaid and can you get it waived, I would tell you. Mr. G got denied by the ALJ with a vocational witness for no jobs, generative distance. Again, most vocational witnesses, there'll be 3, 4, 5 questions. So if the vocational witness, one question was no jobs, maybe one of the other ones, there were jobs. So again, I would look closely at that ALJ denial. I would also get a copy of the audio and listen to it. Because again, if you are right and the only question asked of the VE got the response no jobs, the judge misstated what the VE testified to, that is grounds for appeal. So I would definitely get that. Mo says, I'm conflicted on this. 63 nurse working after cervical fusion and working because you need the money. Everybody's subject to file SSD as listen to the penalties. Why risk it versus struggling to work? I would tell you, Mo, that if you're 63 and you're working, as long as you can work. You're going to make more money. You're going to be happier. Is a sure thing. You file for disability, you don't know what's going to happen. Now, at 63, you could take early retirement and file for disability. If you get approved, you'll get the bump up to full retirement. But I would say if you can work, keep working. It's definitely better. It's not penalties, I don't think that's going to really happen here. That's pretty unusual. So I don't think the penalties are the problem. I think it's just a matter of the delay. And it could be a couple of years. And again, you can get your early retirement, but the risk would really be that they approve you, or they don't approve you and you're stuck at the early retirement amount. But I would say if you can keep working, keep working. And if you need the money, you need the money. Here's that with GR with the partial approval and the $20, which I very, very much appreciate. You're in Athens, Georgia, you're up the street, go Dogs. Okay. Go Kentucky Wildcats asks, how is SSD calculated? They do a calculation, and quite frankly, I looked into this one time, and it's kind of Greek to me. There is a calculation. I'm not the person to ask about it. I don't know. ALJ hearing on April 2nd. I think you said August 2nd. Darn it, Kathy, I was hoping you're from the future, but you're not. So I think that you have limited hand use to fail surgery. Yes, you're going to win. I think there's a good chance you're going to win, although, yeah, I'd be real surprised if you don't win. Wowbro, SS insists of a payee. Psychiatrist said, no, running out of money. The first thing you're going to payee. Yes, unfortunately, it is legal. They can ask you for a representative payee, which kind of sucks because then you got, somebody else in your business, but they can demand it, especially in a mental health. It's a perk interview. Yes, it is for SSI. That's an income and resource interview. Yes, that is for SSI only. How can I make a donation? Not familiar with how to make a donation. I believe on YouTube there is a place on the bottom there. I'm not looking at my YouTube channel here, so I'm going to have to rely on just looking at YouTube, and you'll see a place where it says make a donation there. If I pull up my YouTube, it'll start playing, and but I would just say look at your YouTube. I'll see if I can get a screenshot of that for next week. Let me just see here. Maybe I can do it real quick. Give me a second here. Let me go to the live. Let's see how we do it. I would like people to know how to do it for obvious reasons. Well, I do not see it. If there's a way to do it, I do not know. Don't know for certain. I will try to find that out because, again, I appreciate it. You don't need to do it, but I really appreciate it if somebody does. So there is a way to do it. I just don't know how to tell you how to do it. Maybe a GR can tell us how you do it. Maybe it's simply on the YouTube channel itself. I don't know if it is on the YouTube channel itself. Don't know. I got to find out. So again, I will find out. But anyway, but I appreciate that. Thanks, GR. I really appreciate it. The $sign at the bottom of the chat. Okay, that would be the answer. There's a $sign at the bottom of the chat. Thank you. Thanks, Rodney, and thank you, L. Appreciate that. And thank you again, GR. Okay, we're getting close to the end, but we'll take a few more. We got a few more here. Super Matrix. I'm 65 in SSD. I like the part-time work, 8 hours a week. $600 or $700. No, $600 or $700 a month is not going to flag you. No, it's not going to put your SSDI in benefit because you're pretty close to being moved over to retirement, so that will not be an issue there at all. $600-700 is not a problem. That's well below both SGA and well below 12 work period. Okay, Evans Disability of California is topical. I'm not familiar with them. I'll check them out. Thank you. St. Louis says, my topic-related videos are the best. Thank you very much. I have a good time with them, and I will give Garrett a lot of credit. He has helped me sort of a consultant, come up with some good ideas and a content calendar. So it's kind of a collaborative effort. Jen will suggest topics. Garrett will kind of help, frame the topics. I record the videos. I'll do the written part of it. But yeah, with the number I've got now, it does help to have some other people assisting. And Garrett and Jen deserve a lot of credit for really helping making that work. Connie is 63 years old. The SS was denied, submitted reconsideration. Been seeing pain management. We'll have an EMG next. Yes, having pain management reports and an EMG will definitely help you and hopefully get you approved. At 63, you got a good shot at it, I think. Daisy Red Fox, will healthcare professionals' failure to diagnose and treat a patient's disability for many years have any bearing? It's going to be a problem because obviously you don't have medical records. So if you've got somebody that says, yes, there was a failure to diagnose, that will help, but you're going to need evidence to show that you in fact were disabled in the past. Because, if your healthcare professional failed to diagnose, that means there's no evidence, which is a problem because you're going to have evidence in a disability case. Lillian says, I'm going my second physical evaluation medical appointment received today, but maybe a consultative, I think what you're talking about. Already had a psych evaluation last year, my favorite. Now it's a physical. Yeah, they can send you out. That's part of their developing the record. They can send you out to as many they want. It doesn't really mean anything. It doesn't mean good or bad. It just means they're sending you out. And usually it's usually a good sign they're sending you out. Mr. Ginseng. Ginseng is a spice or a supplement, I think. But so it's Ginsberg, but I've been called worse, so I'll take ginseng. Which is best, to file a mental health claim or medical claim, or whether do both together? I think that, medical claims, especially things that are objectively identifiable, like, MRIs and CTs are going to be stronger, but mental health cases can be significant as well. Lillian's been 4 years. That's way too long. That's way too long. I don't know why. Again, I would get your congressperson involved. That's just ridiculous. That's way too long. 2 years is the most it should take at this point. 4 years, something's wrong. And I would get your congressperson involved. How long after you receive the award letter? I would say it could be as little as 2 weeks. It could be up to 2 months. Walter Knott, not Nat, Walter Knott. He interjects his pro-Trump politics and really upset me, referred to Kamala Harris as D. That's why you keep politics out of live streams. I have not seen Walter talk about that, but I think it's never a good idea to talk politics anytime because it's nobody's business what your politics are. Hurt the Rep says, knowledge is key. What are your chances of a combination of neck and back pain? Depends on how severe it is. Depends on what medical evidence says. So it just, back pain doesn't tell me anything. How bad is it? What does the medical evidence show? Marie Berkeley, back pain of 1. Now, generally, on a scale of 1 to 10, 10 is the worst. 1 is not much, not very bad. 10 is the worst on a 1 to 10 scale. Generally, I think Elle's right. Generally, back pain is going to be mild, moderate, or severe. And severe, obviously, is going to be more disabling. There's Stephanie. Great info and shares as always. Thank you, Stephanie. And I know we're working on getting Stephanie some updated microphone and other equipment so that we won't have the echoes. We'll get her back on because she was great as far as answering questions. Leah. Hello, Leah. I received my forms after the online application was submitted by our office. Notice there's nothing in the forms with the medical doctors who they are to contact. That would be part of the application that we did. And again, I don't want to talk about your case because it's confidential, but the forms, a lot of them are about your reporting what you have gone through. And if I give you access to screen capture videos where I walk you through how to fill out the forms and I review them for you as well. But they're usually not asking about medical information. It's more about your symptoms from you. Okay, so after your GM fully, you're not sure what that means. To fully favorable, have to receive. Yes, you got to receive your award letter, correct. Thomas, Garrett's getting all these questions. Well, trying to work where you're trying to claim benefits affect your disability decision. You want to keep your work below SGA and probably below trial work period. Because if you use up your trial work period, you're over $1,110. That starts to look like you're working fairly substantially. If you're over SGA, theoretically, a judge could say, we're going to give you your 9 months, but I would say keep it below trial work period of 1110 if you're going to work ongoing, I think. Kelly, thank you, Kelly, for the $9.99. I appreciate it. I would say get a cup of coffee. I don't drink coffee. I just never liked it. I don't have a problem with it. I just don't like the way it smells. Don't like the way it tastes. I don't like caffeine. I don't like the way it makes me feel. But I will get a cocoa, but it's too hot for cocoa. So, but I'll get how about if I get a sandwich? I like sandwiches, although you probably heard about this listeria outbreak, for the sliced meats. So I'm kind of going to be reluctant to get sandwiches until that's all done. I get a chicken salad or a tuna salad maybe, but there's a couple places. There's a really good Italian deli near me called East 48th Street. If you're ever in Atlanta, check it out. And they make really good sandwiches. Good chicken salad, tuna salad, mozzarella and tomato, really good. So anyway, I'll get a sandwich for the $9.99. But I appreciate that, Kelly. Thank you. And I'll be, as I eat my sandwich, I'll be raising a sparkling water to you. Thank you very much. Okay, we're going to go another maybe 10 minutes here because I started a little bit late. Ray Stroud, age 41, worked up to application date, however, used a scooter that helped me. He raised the one who was getting paid basically for full time, but really getting special considerations and working only 12 hours a week. Can't stand or lift and getting help. Like I said, I think the big issue here is you're getting paid. If you were not getting paid full wages and you're not getting paid, whatever you're being paid, 50, 60,000, whatever it is, I think you'd have a better argument. But you're going to be basically saying, I want to be found disabled back to 3 of 2020 when I was still getting paid full wages and, I was, getting help from my coworkers. I think a minority of judges would say, okay, we'd consider that. Most of them would say, don't be greedy. They're going to say you're getting full pay, and when you stop getting full pay, we found you disabled. I would personally probably not appeal that based on what you're telling me. But I would talk to an attorney, get some different opinions, but I personally would probably not appeal that. All right, Carlos, why did my ALJ cancel postpone my hearing? Is something wrong? They may have gotten sick. They may have gotten overbooked. I've had a couple of hearings canceled this year. It's usually because the ALJ is just not feeling well. Gold breaks 2,500. Not sure what that means. Gold breaks 2,500. Don't know what that means, Krista's gaming channel. Sorry, I don't know what you mean. Maria, I'm not always in severe pain when I am. My mobility is affected for about a month or 6 weeks. My hips are always stiff. I think I would keep a pain diary, Maria. I think that, if your pain is, not severe all the time, but you can say, that in an average month, there are 2 weeks where your pain is at this severe level consistently, that it's triggered by overdoing it or by, something specific. And that you can say, over a period of time, over a year, you're going to have a significant percentage of the time. You could use percentages, 30% of the time I'm in severe pain. And, you talk about what you cannot do. And maybe you could talk about my pain is always at a level 4 or 5, but that, 30 or 40% of the time it spikes up to an 8 or a 9. Or for at least 2 weeks a year, it spikes up to an 8 or 9. That may be the way that you might do that. Jen is talking about the medical marijuana, I'm thinking. I'm just going to add, we'll talk about it tomorrow. But, hopefully, a serious, mature person like Jen would not be dabbling in medical marijuana. Hopefully. All right, Ray Stroud, I'm awesome. Okay, I thank you very much, Ray Stroud. Marie, about 13 disabling conditions. My back and hips makes it hard to do sit-down jobs. I would tell you, if you have 13 conditions, I would probably tell you to focus more on just the main 2 or 3. 13 is a lot for Social Security to take into consideration. So I would probably tell you, focus on a few less than that. Okay. Ravinia, okay. Do ALJs look at CE reports, and what do you see discrepancy in the CE reports? Hopefully, okay. The ALJs do look at CE reports I think most of them will pay more attention to your ongoing doctors, but they look at the CE reports and sometimes they can use that to make a decision. I also agree. I hope that you get Ravinia a decision so we can move on that. Okay, we're getting close to the end here. Deb, we got a couple of new faces, which I really appreciate. Still 99 people online here. Deb has, I'm 56, have severe arthritis in fingers and wrists, have been here at the end of the month, have a BS degree and worked as a construction inspector for the sewer department. What are your chances? Again, I think if you've got severe arthritis and you can't lift, then you have a grid rule argument. The grids talk about light work. If you can't lift 10 pounds frequently, 20 pounds on occasion, then you meet the grids, assuming that your pain level would interfere with attention and concentrations. I would look at grid 202.06. I think that would be your best argument for it. Christina is, okay, says hello, Stephanie. Okay, Jennifer says hello to Mark. Okay. American Black Holocaust survivors. Nature Trails. There's an anesthesiologist with a channel called Medical Secrets. He made a video called Stingy Doctors. I hope this helps. Okay, we'll check it out. I've been in Norco, which is a opioid. Probably 10 years to treat pain, chronic venous insufficiency with chronic ulcers. Yeah, that's pretty heavy-duty stuff. At my hearing, I'm a skilled worker my whole life, industrial setting, worker lady, vocational expert said I can't do past work, but can do floor waxing. Again, they're saying that based on the hypothetical the judge gave. It doesn't mean you can do floor waxing based on the hypothetical the judge gave. Stephanie Joy is a great disability attorney. Yes, I agree. Stephanie is a good friend of mine, and we talk a lot about disability matters, and she's very good. That's why I have her on, because she knows what she's doing. Okay. Okay. Again, Deb, I think all these things are, let's see if I can go back to your other question here. 56, severe arthritis in fingers, hearing in the month. Yeah, if you've got foot issues, asking a little bit, walking, non-healed bone. Yeah, I think the grids are really going to be a real important thing here. What do we have to complete the same forms more than once? Okay, we get this question a lot. Jen, my paralegal, says, because they want to give you something to do so you won't be complaining to them. Part of it, and part of it is because these things take so long, things change. That's really the best way I can answer that. There was no vocational expert at Malik's hearing. Good sign, 53 chronic pain due to several. Usually a good sign. Usually if the judge doesn't call it, means it's good enough. You don't really need it. Okay. L. Okay. Thanks. Maybe she's answering. Thanks to me explaining what's in the background there. LOL. Okay. That's probably what's in the background. Maybe next week I'll put a mask back there or something just to shake it up. Okay, we're going to go another couple minutes. How long could the second CE should expect a decision? Or again, it's just going to depend on how fast the adjudicator gets it to the medical expert. I would tell you wait a couple of months. Mark, thanks for answering my comment. More to it, but you give me good insight. Thank you, Mark. James McDougall, migraine, mood instability, sleep disorder case, 39 years old. Uphill battle. I think if you go to a migraine doctor and you show you've tried multiple migraine meds without success, that could be helpful. Go to a neurologist or a headache doctor. That would be a really helpful thing. Keep a headache diary. That would help. Mood instability, hopefully you're seeing a psychologist. You're going to need really, really significant records, but I think a pain diary, sleep diary, those things would all help. But going to a specialist, a neurologist, headache doctor, headache clinic, would be helpful. A sleep specialist would be helpful. A psychologist. You're just going to need a lot more evidence because you're young. What is a pain management doctor? Basically, there are some doctors who, after you go to let's say an orthopedist, they may say, you're not a surgical candidate. We're going to send you to long-term pain management. Then there are doctors, they call them physiatrists, is a technical term, but they're pain management doctors, and they basically prescribe pain medications, and you have to typically sign a contract with them where they monitor it, but they are basically going to help you. They may do, injections. They may do, radiofrequency ablations, very, very minor surgical proceedings, but they are just dealing with pain. They're not really dealing with the underlying causing of it. They're not trying to cure you. They're just trying to help you survive and maintain with pain. Okay, we got time for a couple of more here. TLJ, traumatic brain injury, skull fractures, multiple not sure what herniation, scoliosis, 1,000 pages of medical records, orthopedic. You'll say how old you are, but that sounds pretty good to me. LaQuisha, I have a hearing specialist. She keeps telling me to wait for a written decision. Is that good? Yeah, you got to wait. I mean, there's no other way to do it. They're going to have to wait. Okay, and that's just part of the process. I won my claim in the first hearing, got remanded just to my second hearing. My attorney says the judge says still made a listing. Will be expedited, possibly. Possibly. Yeah, Kathy was saying she meant April. She said August. I think we know that. Okay. Yeah, I think Elle's making a very good point about what pain management is, and she's very right. Okay. Okay, we're going to have time for a couple more here. I'll just zoom through them. Moderate spinal stenosis, 34 years old, second time. That's a tough one. That's going to be hard because you got moderate stenosis, you're 34, major depression, IBS could help, but 34 is the real problem. That's the big issue there, I think. Reviews backlog, they've stopped reviews until September or 1st of October. They're going to just send you a form is what they do. St. Louis is not a coffee. V8's good. I like V8. I'm not a coffee person either. Okay. Would a history of attacking coworkers due to PSD flashbacks? Yeah, I think especially if you go to those coworkers to write you a statement saying that I got attacked. Yeah, I think that would show that, that would eliminate jobs for interacting with coworkers and so forth. So yeah, I think that could be helpful. Okay, we're going to do one more. Okay, Roy's praise. Okay, great. Thank you, Roy. All right, and we'll next to the last one. I know there are a couple others. I just went to the last one here. Retiring due to severe pain due to back issues, severe back surgery 46 years ago. Vacation time spent pursued by normal income. I claim, yes, if you're not working, even if you're getting paid, but you're not going into work, that does not count. So a difference from the person who was actually going in but working part-time with help, they were actually going in. But if you're just getting accrued benefits, different story. That's a whole different story. That's not going to be a problem. So I think if you retire and approve and go for benefits, that's not a problem there. Okay, we are now at 10:41, about 10 minutes past what I normally do. So I'm going to go ahead and call it now. Need my beauty sleep, as you can all tell. And we'll be back next week. I see we had, over 100 people here, which is great. Tell your friends, the more the better. It helps me build my YouTube channel. But really, thank you very much. And again, if you don't mind, if you have a chance to leave me a review, there's a link down here. And if you want a case evaluation, you can go to there. And case evaluation, both are much appreciated. And, again, I really appreciate everybody's time. This is a blast. And I hope everybody has a good, safe 1st of August and stay cool out there. So for now, I'm going to end it. And we'll see you all next week. Bye-bye.